Ripple keeps achieving one victory after the other in its case against the SEC. Will this now be the final winning moment for Ripple? Or will the SEC be able to turn it all around? Stay tuned till the end of the video to find out. But first, we are giving away $500 at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comments section. Welcome back to XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribe. Ripple was able to establish that Hinman's 2018 speech was not only his own opinion, but also in line with SEC regulations after learning of an email chain between the SEC and a third party. It has been asked by the judge that it be reviewed. Former SEC Director William Hinman is at the center of the debate since he gave a well-known lecture in 2018, during which he declared that Ethereum is not a security, causing the price of ETH to skyrocket. Ripple's legal team has uncovered descriptions from the SEC privilege log that appear to be extremely pertinent to this issue, and they think that these descriptions are correct. It claims in one email exchange that the complaint is about concerning discussions with a third party, which defendants understand has received guidance from the SEC to analyze its digital asset under the framework set forth in Director William Hinman's June 14, 2018 speech. The SEC sent an email to a third party telling them to analyze a digital asset using the factors in the Hinman speech, which speech was just his personal opinion. I understand now, it's the SEC that needs clarity, Attorney Jeremy Hogan remarked at the time, referring to the agency's paradoxes. In other cases, the document may be used to explicitly establish that Hinman's remark was not only a personal opinion, but was in fact in compliance with SEC policies. This has been a key source of dispute throughout the trial. Even more importantly, if the judge determines that the SEC spent the whole time claiming that Hinman's comment was only his personal opinion while simultaneously making recommendations based on that speech, the SEC will be in a difficult position for the duration of the legal proceedings. Earlier today, Judge Sarah Net Byrne issued a breaking announcement stating that Ripple's request had been granted, and that the papers and email chain will now be included in the in-camera review. Defendant's request is granted. The SEC shall submit the two documents related to the SEC meetings with law firms and the email chain for in-camera review, along with a submission explaining its privilege assertions for each of those documents, no later than October 15, 2021. The SEC shall file a redacted version of its submission on the public docket. Defendant's response is due no later than October 22, 2021. So ordered. Ripple has just submitted a fresh answer to the lawsuit on the same matter, and it is unclear when the judge will complete his evaluation and deliver a judgment on the SEC deliberative process privilege problem in the meanwhile. Defendants, led by attorney Matthew C. Solomon, contend that the deliberative process privilege, DPP, does not exist since the Securities and Exchange Commission, SEC, has never considered policy on digital assets. Because of the actions of Ripple's counsel, the SEC is being forced to choose between two options. Because its employees' opinions become policy, there is a DPP case to be brought against the SEC. However, Hinman's statements and the views of other SEC officials can be used as evidence against the SEC in a lawsuit brought against the agency by investors. According to Hinman, the ideas stated by its officials, including those presented in his speech, are just personal beliefs, and as a result, no claim to deliberative process privilege can be asserted in the context of digital assets. According to reports, a memorandum from the Securities and Exchange Commission's Division of Corporation Finance related to legal analysis of XRP was sent among select SEC workers on June 13, the day before Hinman's speech. Judge Sarah Net Byrne will make the judgment on the privilege issue, but the SEC has already been ordered to turn up many of the documents to Ripple's attorneys, and the agency has refused to comply with the judge's instructions despite her orders. Ripple is suing the SEC for breach of contract. By the way, do you believe this achievement will finally spell the win for Ripple? Let us know in the comments section down below. There's little doubt that the SEC is firing its final shot, and the prognosis for the financial watchdog seems bleak at this moment. It looks that Ripple will triumph in the long-running SEC against Ripple case, despite the fact that the expert discovery deadline has been extended to November 12. Also of note, one of the most controversial topics in the case relates around the recordings of internal meetings that Ripple was obligated to make available to the parties. Securities and Exchange Commission, SEC, has already criticized Ripple's search algorithms, describing them as flawed. Additionally, the regulator requested pre-motion conferences for orders in order to compel Ripple to produce the recordings that were in issue. Ripple has now given 3 major justifications in favor of its stance that the SEC's request should be denied. These arguments are as follows. A document submitted on October 8 by Ripple Labs counsel claimed that the fact discovery deadline had passed and, furthermore, that the SEC had authorized Ripple's search strategies for its recordings, despite the fact that the SEC had not yet consented to such methods. Later, the petition said that Ripple had fulfilled its obligations by performing the previous search, which was supported by the evidence. Unless it reviewed more than 4,000 recordings in total, according to the firm, it would be impossible to find any further records. The fact that Ripple performed a comprehensive and reasonable search was also highlighted in the petition. Ripple also claimed that as part of their appeal, they had generated 170,000 papers and 1 million pages that were relevant to search keywords that were targeted by Ripple. Also, make sure to write your thoughts on these reasons presented by Ripple in the comment section. It continued by saying, Ripple's prior productions include hundreds of documents that reveal the substance of many internal meetings, including meeting agendas, slide deck presentations with detailed speaker notes, and summaries and discussions of the meetings. The attorneys also argued that further unproduced recordings were duplicative of the original and should be removed from circulation. According to the documentation, the SEC boiled the ocean demand as flatly incompatible with the federal rules, and given the massive amount of material already produced in discovery, the SEC request is disproportionate. The SEC allegation that it had refused to search the contents of some recordings was also contested by Ripple, who claimed that this was a breach of the law. A footnote in the paper said that the SEC overstates the relevance of recording evidence. And this was supported by other sources. So, if we see the final win for Ripple, how high will its value be? I believe it should be worth the amount of Ethereum that it costs to purchase. XRP, on the other hand, is unlikely to have received the same exemption based solely on its utility, and we'll never know because the winners have already been chosen and all other tokens have been screwed by the SEC and the thief who stole Ripple's technology, which means that all of the value of Ethereum would be Ripple's value, rather than the thief's value, as a result of the thief's theft of Ripple's technology. What do you think about Ripple's win chances after this latest win? Will it really be as high valued as Ethereum after winning the case? Let us know in the comments section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.